Okay, we're going to get started. Welcome, everyone. This is one of a series of virtual side events presented by the World Coalition Against the Death Penalty and the Advocates for Human Rights and other members of the World Coalition to help prepare for upcoming Universal Periodic Reviews. The upcoming Universal Periodic Review starting on November 1st is UPR39. And there are at least 9 retentionist countries slated for that 2-week review period. And we're here today to talk about all of them. So we won't have a lot of time to go into a lot of depth on each country, but hopefully for those of you who are also preparing for the UPR session, particularly delegates to the Human Rights Council, we hope this will be a useful session to give you an overview and some suggested recommendations for the UPR session. In terms of logistics, if you have questions for any of the panelists, please use the Q&A function. That's going to be the easiest way to communicate with us. I'll also note that we are recording this session, so please bear that in mind. We may be posting it with the permission of all of the panelists. We may be posting a recording of this session to our YouTube channel and making it available to people who are not able to attend but still want to have access to the content. If you have any questions, you can contact Elizabeth Lacey. You'll see her email address up on the screen. And this session is presented by not only the Advocates for Human Rights and the World Coalition Against the Death Penalty, but Greater Caribbean for Life, Reprieve, the Capital Punishment Justice Project, apologies, Matthew, and Eleos Justice at Monash University. So we're really thankful to all of those partners, and the Anti-Death Penalty Asia Network also is a supporter of this event. So today's event is also a part of World Day Against the Death Penalty, which is marked every October 10th. That's this Sunday. And this year, every year, the World Coalition coordinates World Day Against the Death Penalty. The Advocates chairs the World Day Working Group. And this is the 19th World Day Against the Death Penalty with the theme Women Sentenced to Death, an Invisible Reality. And we're hoping to highlight those issues in events that are going on all around the world, starting yesterday and through Monday. There will be a lot of different events to raise death penalty issues and raise awareness about women who are sentenced to death or executed. So we hope that you will attend more of those events and pay attention to it on social media and the mainstream media as well, and lend your support to the campaign. This presentation is funded in part through the European Union, and we're thankful for their support as we help build the capacity of members of the World Coalition to engage in advocacy at the United Nations. So with that, I think I'll ask Katya and Elizabeth to take down the PowerPoint. We don't need to have any more slides in front of you. Instead, we'll see faces. And our plan of action is to go through the countries and give each panelist a chance to speak briefly about those countries. Of course, for any country that has the death penalty, that retains the death penalty, we would love to see recommendations to abolish the death penalty, to institute a formal moratorium if there isn't already one in place, and to ratify the second optional protocol to the International Covenant on Civil and Political Rights. Those are what I like to refer to as the obvious recommendations that delegates to the council can make for any country that has not formally and finally abolished the death penalty. What I think would be most interesting today is to hear from our panelists about what additional recommendations they might like to hear coming out of the Universal Periodic Review interactive dialogue process, recommendations that might be a little bit outside the box, recommendations that might be more likely to be accepted by the state that's receiving them, and recommendations that might make more incremental or step-by-step progress toward abolition as that ultimate goal. So I think that might be a helpful way to approach it for our audience attendees. We'd love to hear any recommendations on the floor of the council relating to the death penalty, but we thought this would make it more useful to all of you. So with that, we'll start with Matthew Goldberg. He's going to be speaking about Papua New Guinea, and he is the president, newly elected, of the World Coalition Against the Death Penalty, also representing Eleos Justice and the Capital Punishment Justice Project. So Matthew, I'll turn it over to you to talk about PNG and what recommendations you would like to highlight for our attendees.
Great, thanks, Amy, for the opportunity. I'm really grateful to the Advocates for Human Rights for coordinating this event. And as you've acknowledged, it's really pertinent that we are gathered today to explore anti-death penalty advocacy on the precipice of the World Day Against the Death Penalty, and while we're waiting for the outcome of the Human Rights Council's vote on the resolution concerning the question of the death penalty that we expect will be adopted either this afternoon or tomorrow, and should form another key plank in the actions that we're recommending take place within UPR39. So that said, Amy, taking your lead, I'll begin by identifying what we may term a related recommendation, really endeavouring to reach beyond the admittedly standard form, but nonetheless primary and entirely essential recommendations that we seek are made concerning the absolute and irrevocable abolition of the death penalty at law, and certainly we don't in any way resile from those essential recommendations. But to that end, in relation to Papua New Guinea, we'd really also seek to highlight the fact that the PNG is still yet to establish a national human rights institution in accordance with the Paris Principles. And this UPR cycle is really another chance to ensure that that recommendation is made and underscored, and that the desirability of an NHRI in PNG is really profoundly supported by states participating in the UPR process. Governments of PNG have indicated a preparedness within previous UPR reporting and in other forums to establish an NHRI, but that really hasn't translated to discernible action to formally bring about the establishment of that key body. And so this working group session could very much be framed as a moment at which those efforts and those positive indications and recognition of the value of the institution could culminate in very tangible undertakings. Maybe it's a chance for a real roadmap to be established such that a critical institution of that kind could come to be in PNG. And that would really have the effect of better safeguarding and enhancing human rights in the country. Very briefly, drawing upon submissions that were made by colleagues at the Diplomacy Training Program and in collaboration with the Pacific Islands Association of Non-Governmental Organisations, we really think it's important to recognise that establishing an NHRI would go a long way to building capacity in PNG to successfully address the sort of challenges and impacts upon human rights that arise in the public and private sectors. Important from our perspective to highlight that related recommendation. And then within the brief additional time, I might just, from one perspective, subvert the model here to a small extent, and also really emphasise a notionally traditional recommendation, but one that's of particular resonance at the moment in PNG, and that is to establish an official moratorium on the imposition of the death penalty. And I only revert to that stance because of very recent events, a determination in the Supreme Court of PNG to quash a national court's temporary stay that was functioning to protect the 15 people on death row in PNG from executions. Arguably there was some level of complacency or at least some confidence that executions wouldn't take place in PNG and that very stable and extremely long-standing moratorium conditions would be sustained, at least since 2017 when the National Court made that finding and imposed the stay. That stay doesn't have application any longer. And so that level of confidence doesn't fairly exist now when having regard to circumstances for people on death row in PNG. It remains absolutely the case that no executions have taken place in the country since 1954. And so from the anti-death penalty movement's perspective, the de facto conditions exist nonetheless, but in the absence of a legal protection for those on death row, we think it's really quite important and significant that states with the capacity to do so at the UPR session do underscore and emphasize that there's a way through formal undertaking and appreciation of the circumstances in PNG that the government moved to formalise moratorium conditions and re-establish the protection against execution for those who've been subject to death sentences in the country. So those are the two aspects of the recommendation process that in the context of this gathering, I think I can highlight at the moment. Thanks for the opportunity.
Fair enough. Thank you, Matthew. And of course, as president of the World Coalition, you're welcome to break the format and break the rules. We'll give you that allowance. Thanks. So with that, we'll move from Papua New Guinea to Tanzania. And about the subject of Tanzania, we're going to hear from Innocent Mrema from Reprieve. So Innocent, tell us about what priority recommendations you would like to see made during the interactive dialogue on Tanzania beyond the usual: abolish the death penalty, institute a formal moratorium, ratify OP2. Go ahead, Innocent.
Okay, thank you so much, Amy. I would first like to just give a general background of the situation of the death penalty in Tanzania. It's worth noting that according to law, it has to be handed down to persons who have been convicted of crimes like murder, treason, and in some cases, terrorism, where there are some acts that have led to the death of any person. And therefore, we should note that from 1995, the death penalty has not been practiced in the country, despite being handed down by the national courts. As of 2019, for example, it was noted by the Legal and Human Rights Center, which is one of our partners, that the court in the country did hand down more than, did hand down more than 19 death penalties. And if one is to make more investigation into this, he or she will note that those who fall victims in this practice are those whose rights has been violated by the state, including the right to effective legal representation, the right to translators, and even consular rights, where you find that the concerned persons are nationals from other countries. And given the fact that they don't have the right to bail, they find themselves in prisons facing appalling conditions, including poor food or lack of balanced diet, and even lack of medication, given the fact that some are HIV positive and do have other underlying health conditions. And as if it was not enough, the country even decided to withdraw its declaration that allowed individuals and NGOs to file cases with the African Court on Human and People's Rights. The court that decided in 2019 that the mandatory nature of the death penalty in Tanzania was not a just cause and therefore wanted the country to withdraw it. It is due to this background that we would like to recommend that an investigation is to be done so as to understand the injustices coming out from the mandatory nature of the death penalty itself, and even to understand the prison conditions where you find inmates are there trying to struggle due to the hardship they have to face. We also recommend that the government ratifies the second optional protocol to the International Covenant on Civil and Political Rights, and therefore abolish the death penalty and commute the sentences of death to sentences which are just and in compliance with the international human rights standards. We also recommend that the government reinstates this declaration that would allow individuals and NGOs to file cases with the court, in addition to ensure that there is training to police officers for them to understand the constitutional rights of those accused of offenses of murder, for example. We would also like, therefore, to recommend as a kind of repetition that more investigation is to be done in prisons so as to understand the conditions that inmates do face. So those are some of the recommendations that we would like to recommend. Thank you.
Thanks so much, Innocent. Yeah, I think your suggested recommendations really emphasize the importance of fact-finding and documentation. We need information in order to do effective advocacy. And when the government withholds that information, that can make it very challenging to identify the human rights violations, to hold the perpetrators accountable, and to provide the necessary support and assistance to victims of those human rights violations as well. Great. So thank you for that great picture of the situation on the ground in Tanzania and how UPR recommendations could help advance progress toward abolition in the country. Next, we'll turn to Homotso Magagula, who is a former intern with the Advocates for Human Rights and hails from the Kingdom of Eswatini. So we're delighted that she was willing to rejoin us today to speak more about death penalty issues in Eswatini and share the expertise that she has both prior to joining the Advocates and while she was doing her internship with us. So Homotso, you have the floor.
Thank you. Thank you, Amy. I think I will also start with a brief, very brief sort of contextual piece. And I think that might be helpful for some of the recommendations that I will talk about today. So the first thing is that Eswatini hasn't handed down a death penalty sentence since 2016. So although one person remains on death row, there haven't been any additional sentences handed down since then. And of the 44 that have been handed down since 1983, 44 of them have been commuted. So that's sort of a general understanding of maybe the statistics of who's currently on death row. And so moving into my recommendations, I think the one that I would like to highlight the most today is to ensure that all human rights defenders are free to express criticism of authorities and the monarchy, consistent with the country's obligations under the International Covenant on Civil and Political Rights. This is particularly important because treason is still considered grounds for the use of the death penalty under the Criminal Procedure and Evidence Act of 1938 in Eswatini. And given the current political and social conditions and the growing civil uprising, there's a lot more threat to civil rights defenders and sort of grounds for the courts and law enforcement to use treason as a reason to give out death penalty sentences. And so that ties back to, you know, establishing a moratorium of it, but sort of given the current state of affairs, that threat to human rights defenders and people who are critical of the current political system is increasing. So that's definitely something that I think would be very important to push forward as a recommendation. And then connected to that, I would sort of also push forward the recommendation to prohibit courts from considering evidence obtained through torture and other forms of cruel, inhumane, and degrading treatment. So the way that evidence is acquired will definitely affect different court cases and how sentences are handed down. And so if there are no current safeguards that prevent courts from using evidence that has been acquired through torture, then there are no additional protections for human rights defenders, and that puts them at greater threat of potentially receiving death penalty sentences, especially as I've mentioned, given the current state of affairs today. And so this would be something that would allow for people to continue to call for change with a level of protection at the legal level, that their cases would be heard fairly. And so I think it's incredibly important that the court system also amends some of its policies and procedures to cater to that reality as well. And I think that's where I would end for today, and I'll hand it over back to you, Amy. Thank you.
Thanks so much, Homotso. We really appreciate your insights about Eswatini. Next, we're going to hand off to Leela Ramdeen, who is the Director of Greater Caribbean for Life And Leela has a lot to cover because there are 3 different Caribbean nations that are up for the upcoming UPR session: Antigua and Barbuda, St. Vincent and the Grenadines, and Trinidad and Tobago. So Leela has a lot of ground to cover, and I'm sure she'll do an excellent job of helping you sort out and not confuse the 3 different countries and what the priority recommendations would be for those countries. So Leela, thanks so much for joining us, and I'll give you the floor now. Oh, Leela, I think you need to unmute yourself first.
Okay, so
Perfect.
I'll be addressing Antigua and Barbuda, St. Vincent and Grenadines, and Trinidad and Tobago. First of all, Antigua and Barbuda. Antigua and Barbuda, the last hanging that took place there was in 1991. And there's no one on death row currently. I'd like to highlight 2 specific recommendations, particularly because of the efforts of my group, the Greater Caribbean for Life, to raise awareness, to get our governments to work with organizations such as us. So the first is collaborate with civil society organizations in the Caribbean to conduct a comprehensive public awareness raising campaign to educate the public about international human rights standards as they pertain to the death penalty and alternatives to the death penalty. So organizations like ours, GCL, we're willing to partner with them on such campaign. Years ago, a former Assistant Secretary General for Human Rights, Ivan Simonovich, he urged UN member states not to rely on opinion polls in favor of retention, noting that public opinion can be based on misconceptions and that empirical evidence proved the more a population was aware of facts, the less it supported the death penalty. And the Death Penalty Project rightly says government should not continue to cite populist sentiment as a justification for neglecting their commitments to human rights, which is what many, well, the English-speaking Caribbean, as we know, they're all retentionists. And they always tell the public, well, the public want the death penalty. So that, you know, we have, the governments have to be creative and bold and, you know, do what is right in the 21st century. So the public need to be encouraged to consider alternatives to the death penalty. For example, different forms of life sentence with reviews built in and with the possibility of parole. And there should be discretion in applying the maximum sentence that replaces the death penalty. So we want that particular recommendation, please, to be highlighted. The second one I'd like to highlight is the one that states introduce alternatives to imprisonment for minor offenses. This is a problem throughout our region. Given the current overcrowding at the prison in Antigua and Barbuda, it's difficult to see how any meaningful rehabilitation can take place. And some inmates who are incarcerated for minor offenses are at risk of being drawn further into crime, as they may make friends with others who have been incarcerated for more serious crimes. There's clear evidence that happens in our region. Often when prisoners are released, they have difficulty finding work because they have a prison record. So I would like to recommend that we focus on that and share alternatives to imprisonment, which could include community service for minor crimes, electronic monitoring, transformative justice, restorative justice, periodic detention, residential, drug or substance abuse programs, which some of our countries are using. So those alternatives to me for minor offenses, we really should highlight. So I want to focus now on St. Vincent and the Grenadines. St. Vincent and the Grenadines, as we know, there are real problems because, well, there's only one person on death row. And the challenge they have is that there's limited public representation and no legal aid system in St. Vincent and the Grenadines. So the 2 recommendations I would like to highlight: ratify and support key international agreements opposing the death penalty, including the 2nd optional protocol to the International Covenant on Civil and Political Rights and the UN General Assembly Moratorium Resolutions. The ICCPR, as we know, is a key internationally legally binding treaty that contains important guarantees for the protection of civil and political rights. The ICCPR, together with the Universal Declaration of Human Rights and the International Covenant on Economic, Social, and Cultural Rights, are considered the International Bill of Rights. And the second optional protocol, which we want them to ratify to the ICCPR, obliges state parties to abolish the death penalty. In December 2020, once again, St. Vincent and the Grenadines voted against, like the other Caribbean, English-speaking Caribbean countries, voted against the UN resolution to establish a moratorium on the use of the death penalty with a view to work toward abolition. Most of the Caribbean retentionist states have consistently voted against the resolution and have signed a note verbale dissociating themselves from the moratorium. Together, though, these countries, although they're small, comprise about 25% of the total votes opposed to the call at the UN General Assembly sessions. And for countries to, each time, the last one, as I said, was in December 2020, the call from the UN is for countries to adopt the resolution to establish a moratorium on the use of the death penalty with a view to work toward abolition. And somehow our countries, once or twice they abstained, but last time again, they all voted against the moratorium, even though in fact they know they can't hang because, well, I'll come on to that, the last hanging in our region was in 2008, Charles Laplace in Kitts and Nevis. And because of the restrictions placed on our countries by the Privy Council, most of us, that's our final court of appeal, they know they can't hang, and yet they will not take the bull by the horn and move forward. The second recommendation that I'd like to highlight for St. Vincent and the Grenadines is to increase the resources and personnel available to the justice system so that there are sufficient judges, lawyers, and paralegals to minimize the backlog and reduce pretrial detention period to durations that comply with international standards. Now, it's essential that St. Vincent and the Grenadines continues to devise and implement backlog reduction programs, legal and policy changes to backlog reductions, and to consider potential future solutions, including capacity building technology and information systems. St. Vincent and the Grenadines has limited public representation and no legal aid system, as I said, resulting in prolonged pretrial detention periods. The UN, in its document Principles and Guidelines on Access to Legal Aid and in Criminal Justice System, encourages member states to consider, where appropriate, the provision of legal aid and to provide such aid to the maximum extent possible. Principle 3 says, states should ensure that anyone who is detained, arrested, suspected of, or charged with a criminal offense punishable by a term of imprisonment or the death penalty is entitled to legal aid at all stages of the criminal justice process. And the UN recognizes that legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law. Legal aid, in fact, is a foundation for the enjoyment of other rights, including the right to a fair trial. And also see Article 14, paragraph 3D of the ICCPR, which refers to the right to legal aid if a person does not have sufficient means to pay for it. So there's much work. As you know, there are about 7 recommendations for St. Vincent and the Grenadines, but those are the 2 that I would like to highlight in particular. The third country that I'll focus on is Trinidad and Tobago, my own home country. And as we know, here in Trinidad and Tobago, we remain now the only country in our English-speaking Caribbean region that has the mandatory death penalty. No mitigating circumstances, nothing else is taken into account. And we know that in 2018, I think it was Dennis Byron, who was the then president of the Caribbean Court of Justice. Trinidad and Tobago didn't sign on to the CCJ, Caribbean Court of Justice. Our final court of appeal is the Judicial Committee of the Council of the Privy Council. And in 2018, Sir Dennis Byron and his team of judges, they shot down the mandatory death penalty and said it was unconstitutional in Barbados. We haven't done so. So as the only country with a mandatory death penalty, we're working hard to get them to really abolish the mandatory death penalty. As Sir Dennis Byron said in that case in Barbados, laws should not be calcified to reflect colonial times. All the European, tomorrow I'm speaking at a European Union event here in Trinidad. All the European Union countries, except, well, I think Belarus, have abolished the death penalty. And yet we who were colonized, holding on to it like a yoke around our neck. So, you know, there's a lot of work to do there. So the two I'd like to highlight, just to say that on our death row, there are about 50 people. We have, I think across the region, English-speaking Caribbean, there are about 80. We have the most, about 50 people. And although we know we can't hang because of the restrictions by the Privy Council, last year they handed down 8 death sentences. So knowing, of course, that, and our Mercy Committee is not working. And, you know, let me go into the recommendations. So the first one is we want, again, to collaborate. We want them to collaborate with abolitionist civil society organizations in the region to conduct a comprehensive public awareness raising campaign, to educate the public about international human rights standards as they pertain to the death penalty and about alternatives to the death penalty. So we are Greater Caribbean for Life, and I'm chair of the Catholic Commission for Social Justice, which has some credibility here. We stand ready to collaborate with the government to conduct a comprehensive public awareness raising campaign to educate the public about the international human rights standards as they pertain to the death penalty and about alternatives to the death penalty. Fear of crime and misinformation about the effectiveness of the death penalty influence the public, and so they continue to bay for blood. However, in fact, tomorrow on the panel of the EU, I'm speaking against the death penalty, and there's a senior counsel who's speaking for the death penalty, and he always gives me a hard time. He said he just wants revenge, never mind deterrent, just what. So the baying for blood continues, and when you have senior people like that baying for blood, then the others at the grassroots who are afraid because of the high level of crime, not only here, but in the region, that's an issue. However, research, as we know by the late Professor Roger Hood from Oxford University and Florence Mangal, a psychologist, in a 2011 study in Trinidad and Tobago, investigating attitude towards the use of the mandatory death penalty for murder under Trinidad law, show that while 91% are in favor of the death penalty, only a quarter of them, well, 26%, favored the current law under which the death penalty is mandatory for all murders, whatever the circumstances. So it shows, you know, when you break it down, when you tell people, give people scenarios where in fact they would start thinking, but hang on, this person shouldn't be hanged in this situation. So only a quarter of them believe that we should have the mandatory death penalty. The findings reveal that there is little public support for the mandatory death penalty and call into question the government's continued commitment to this inhumane policy. Removal of the mandatory death penalty from our law books could be the first step towards abolition. In Trinidad and Tobago, because of the overwhelming majority of those sentenced to death are not actually executed, there is in effect some form of alternative to the death penalty already in place. Currently, more than 1,000 persons are awaiting trial for murder. About 50 persons, I said, are on death row, and many have been there for more than 5 years. Therefore, as a result of the various Privy Council judgments from Pratt and Morgan go down, there have been quite a few, the sentences of some of those who've been on death row for more than 5 years will most likely be commuted through the prerogative of mercy. The Mercy Committee, of course, which is supposed to meet every 4 years and hasn't really been meeting regularly. Possible alternatives to mandatory death penalty for murder, we know, sentence to life imprisonment with the possibility, as I said earlier, of review of the sentence, whole life term, with or without parole. For 4 years, I sat on a government-appointed committee to look at introducing a parole system in Trinidad and Tobago. I think the report, which we did so much work on that, but the report is collecting dust somewhere. And then, of course, you can look alternatives at a discretionary sentence, which affords a judge the power to suggest either a minimum term or to impose a whole life sentence. The second area I'd like to focus on for Trinidad and Tobago to highlight recommendation is to create a streamlined process to facilitate the immediate release of any person who's been held in pretrial detention for a term longer than the maximum sentence for the crime with which they have been charged. This is a real problem here. As abolitionists have said, it is essential that Trinidad and Tobago continue to devise and implement backlog reduction programs, legal and policy changes to backlog reductions, and to consider potential future solutions, including capacity building, technology, and information systems. The Caribbean Center for Human Rights notes the entire system is backlogged, beset by chronic delay. Magistrates, over 100,000 cases backlogged in the magistracy. In 2019, Professor Rosemary Bell-Antwine, who was the then Dean of the Faculty of Law at UWI, St. Augustine campus, and a team addressed the IACHR, the Inter-American Commission on Human Rights. And they said to the commission, inter alia, that Trinidad and Tobago has the second highest remand population in the region, second only to Haiti, with some 60% of prisoners on remand. And of the more than 2,271 prisoners on remand in Trinidad and Tobago, 34%, or 1/3, have been incarcerated for more than 5 years. You're on remand, you haven't even been tried. You're innocent until you're proved guilty, and 5 years you waited, whilst 12.5% have been on remand awaiting trial for more than 10 years. And recently, 3 people were, 21 years, they were waiting for trial. We just had the case where two youths, they were minors then, had committed a terrible act. They brutally murdered this 6-year-old child with cane stalk. 15 years for the case to come. Rosemary Bell-Antwine told the commission the problems of excessive detention on remand has assumed exorbitant proportions, pointing out that in some cases, the period of remand exceeded the longest length of sentence prescribed as punishment upon conviction. So if in fact you committed a minor crime and you're there for more than 5 years, and the punishment would have been 1 year, and they're still there, still waiting. So our former Archbishop Joseph Harris started a petition. We got thousands of people to sign it to ask for mercy for those who have committed minor crime. You go and steal a mango, you didn't pay your maintenance, you use some swear words, you obscene words, and you're there for 5 years, 10 years, no. So those are real issues. To me, that pre-detention issue is something that we need to address. So those are some of the key issues that I would like to raise for Trinidad and Tobago, but they apply to all our English-speaking Caribbean countries. And the major one is, please sign the moratorium, at least, because de facto, they can't, 2000, since Charles Laplace, and nobody else has been hanged. The challenge we have with the mandatory death penalty in Trinidad and Tobago, as we know, is the savings clause. Because of the savings clause, once you take away the savings clause, and that's why Dennis Byron said, we shouldn't have, they removed the savings clause in Barbados in that case. We shouldn't have a savings clause. Yeah, we shouldn't calcify our laws based on colonial times. So sorry, I hope I haven't gone over my time, but those are some of the key issues we face in our region.
Thanks so much, Leela. You're such a dynamic speaker and so well informed in the region. So it's really a privilege to be able to hear from you. And I was really struck by your comments on the pretrial detention system in Trinidad and Tobago. And I think a recommendation along those lines would really seem obvious to, as you suggested, because it not only helps alleviate the prison overcrowding and improve prison conditions for the remaining people in detention, but it would also help alleviate the backlog in the court system as well, so that the judges could move on and address the remaining cases at hand. And it would help society to thrive, that all of these people who have been lingering in detention would be able to go out, join society, contribute to the economy, help make society a better place.
Think of their families.
Right, exactly.
Many of them would have been the breadwinner. Think of their families. You know,
right. There's so many obvious advantages to taking those steps. So it's really, I really appreciate you, even though it's not directly tied to the death penalty, it relates to the detention conditions and to the fair trial rights of other people who are at risk of being sentenced to death or who have been sentenced to death. So thank you so much. And I am going to clean up here, to use an American phrase. I'll be briefly covering Sudan, Tajikistan, and Thailand. And I do invite our attendees to pose questions in the Q&A function. Otherwise, I'll pose some questions and maybe the other panelists will have questions for each other as well. So starting with Sudan, and I think I have the privilege of going last because I can highlight some commonalities among some of the different presentations you've already heard. A priority recommendation for Sudan would be to eliminate the mandatory death penalty and require all courts to exercise judicial discretion in considering mitigating circumstances. So we've heard about the mandatory death penalty in several other jurisdictions. And before I jump in and talk about that in the context of Sudan, I want to note that there are some positive trends with respect to the death penalty in Sudan. And I think some of the delegates to the council really like to highlight some positive steps. So Sudan has reduced the number of crimes eligible for the death penalty and reduced the number of death sentences that have been pronounced. Specifically in 2020, Sudan eliminated the death penalty for the third offense of same-sex sexual conduct and for apostasy. But there are still at least 88 people on death row. There were 10 death sentences handed down in 2020. And the death penalty is mandatory for intentional murder, for certain types of rape, and for drug-related offenses in Sudan. A convicted person in the case of murder may obtain a lighter sentence by paying a diya to the victim's family, as is the case in a lot of countries that use some form of Sharia law. But allowing that as an alternative to the death penalty is arbitrary, because people who are poor cannot escape the death penalty by making this diya payment. It also means that somebody who has been sentenced to death for murder, and that murder is in the context of, for example, domestic violence, may not be able to raise funds from relatives and family members. If a woman has been a victim of domestic violence for a long period of time, and she ultimately kills the person who has perpetrated that domestic violence against her, it's unlikely that the victim's family members would grant the opportunity to make that payment. Also unlikely that his family members would help contribute to that payment as well. So it puts, in particular, women in a very difficult situation. And I also want to emphasize that any mandatory death penalty is arbitrary and therefore violates international human rights standards. It's arbitrary because it doesn't allow the sentencing authority to consider the facts and circumstances. And there's a real need in any country that has a mandatory death penalty, not only to eliminate the mandatory death penalty, but to institute training for the sentencing authorities, for the judges, about how to consider mitigating circumstances. To go back to the World Day Against the Death Penalty theme of women sentenced to death, the most common crime for which women are sentenced to death around the world is murder. And it's most likely to arise in a context of gender-based violence, that the woman is a victim of gender-based violence and is engaging in murder against a perpetrator or somebody related to that context of gender-based violence. Now, judges typically, if it's a mandatory death sentence, they're not allowed to consider that woman's circumstances. But even if it is not a mandatory death penalty, we find that judges often don't consider the overall picture of the context in which the crime was committed. And that results in discriminatory effects on women who are charged with death eligible offenses. So we want to highlight that in the context of Sudan, but any country as well, where women are being sentenced to death. Oftentimes there is a gendered component to those death sentences, and women are being penalized for themselves being victims of crimes in that context. Our second recommendation for Sudan has to do with detention conditions for people who are under sentence of death. The recommendation we would suggest is establish mechanisms to ensure that all detention facilities comply with the Nelson Mandela rules, specifically Rule 47. Rule 47 prohibits the use of chains, irons, or other instruments of restraint which are inherently degrading or painful. On death row in Sudan, people are permanently held in shackles. They are held in handcuffs connected to shackles on their legs. It causes chafing of the skin. They are such that they are not able to stand upright. And the shackles remain on at all times, including during medical visits, causing wounds on people's hands and legs. And there was a report of a pregnant woman who gave birth while shackled as well. So we would really encourage that specific recommendation on Nelson Mandela Rule 47 to address shackling. Moving on to Tajikistan. Tajikistan is actually in a decent position, and I'll borrow from Matthew and a couple of the other panelists to break the rules a bit, to suggest a recommendation to establish and publish a clear timeline with concrete steps to accomplish abolition of the death penalty and ratification of the second optional protocol by 2026. There has been an official moratorium in place in Tajikistan since 2004. There haven't been any executions since then. There are no people on death row. And in the second UPR cycle, Tajikistan accepted recommendations to ratify the second optional protocol, but has not done so. In the 2016 UPR, Tajikistan stated that at present they have two options for abolishing the death penalty: using a constitutional amendment or without using an amendment, with the possibility of applying capital punishment in the time of war. It also stated that laws suspending the death penalty and instituting a moratorium had come into full force, and the criminal court has a prison term limit of 20 years. And it stated abolition of the death penalty would take place gradually and would involve addressing issues of administrative, financial, and legal nature. This was in 2016. So 5 years on, they have not made any progress. So we would like to see a recommendation calling for a clear timeline with concrete steps to accomplish this before the fourth cycle UPR. Our second suggested recommendation for Tajikistan is to issue guidelines and conduct trainings on the steps judges must take when a defendant alleges that evidence was obtained under duress. The Human Rights Committee has highlighted the extensive use of torture and ill treatment of people who are detained, specifically for extracting confessions, and the absence of a mechanism to investigate those allegations. So requiring that judges consider and prohibit the introduction of evidence that's obtained under duress or via torture would also be quite useful in addressing some of these fair trial issues. Moving on to Thailand, our last country in our review. Our first recommendation would be to prohibit the death penalty for drug-related offenses. Thailand resumed executions in 2018 after not executing anyone since 2009. So that's a step backward on the part of Thailand. There are 228 men and 29 women on death row, and half of them have been convicted of drug-related offenses. All of the women on death row have been convicted of drug-related offenses, relating again to the World Day theme. So prohibiting the death penalty for drug-related offenses, which do not rise to the level of most serious crimes, would be a very useful recommendation to see. And a second recommendation for Thailand, tying in with things that Innocent and Leela have talked about, is educate the public about human rights and alternatives to the death penalty. In 2017, the Deputy Prime Minister of Thailand stated that the death penalty is important for effective crime prevention, and government officials frequently cite non-scientific public opinion polls as evidence of widespread support for the death penalty, but those polls do not provide the public with sufficient information to make an informed opinion. The government largely keeps the public in the dark about its death penalty practices. So a recommendation to educate the public, to do a public awareness raising campaign, would help call the government's bluff. If they want to rely on public opinion, that opinion should be well informed. And I think that's a common thread among some of the other panelists as well. We want to ensure that to the extent any government is touting out the excuse of public opinion supporting the death penalty, and you'll note that they don't do that to justify any other human rights violations, that they should take concrete steps to ensure that the public are well informed about the death penalty, alternatives to the death penalty, and the human rights issues related to that. So that wraps up our whirlwind tour of the 9 countries that retain the death penalty that are scheduled for UPR39 starting November 1st. We'll move on to our question period. So again, if you have a question, please put it in the Q&A at the bottom bar that you see on your screen. And I'll start out a round of questions with Matthew talking about Papua New Guinea. Other than major political reform, are there any options to secure protection for people who remain on death row in Papua New Guinea?
Sure, thanks, Amy, and thanks so much to all the panelists. That was really expansive and an important discussion. Yeah, I think there certainly are other options, and the starting point for that sort of inquiry is really facilitated by returning to the Supreme Court's findings and exploring the path of reasoning that exists within the dissenting judgment. For those who do that, we can see that there was really expressed reliance upon what we would regard as Pratt and Morgan reasoning and incorporating other related comparative jurisdictional analysis, really highlighting the circumstances of delay that those on death row have encountered. And of the 15 on death row, 13 have been waiting for more than 5 years, and really many far more than that, and at the extreme, up to 17 years since the initial sentence was imposed. And so the, albeit dissenting opinion, was a finding that in those circumstances, that dehumanizing factor of delay really results in a violation of traditional principles within PNG and should mean the protection of the people who've been subject to delay and remain on death row. That's relevant because we can come to think about what's brought on that delay, and in part it's referable to the finding that the Advisory Committee on the Power of Mercy hasn't been capably fulfilling its function because it wasn't necessarily, or it had seemed satisfactorily funded and staffed. And so in those circumstances, the people who've been subject to death sentences haven't been able to access the committee and bring those appeals for orders of clemency that would protect them from execution. So arguably there's now scope, or there always has been some scope, to bring applications to that body, whether or not it's equipped to determine them, there's a related issue. And then beyond that, we shouldn't work on the basis that other domestic remedies have necessarily been exhausted. And so although the temporary stay was quashed and the circumstances of each of those on death row were broadly addressed, the individual arrangements and experience of those who have been subject to death sentences wasn't really explored in any depth. And so it's very possible that each of those who are presently subject to death sentences and don't now have the protection of the stay could themselves, if there was a better examination of their personal circumstances, bring other actions within the Papua New Guinean court system. So that's really relevant to those states who are addressing the fact of the death penalty in PNG at this UPR session, because whilst there's scope for people on death row who are immediately affected by the Supreme Court's ruling to perhaps pursue these other avenues, from our perspective, and I think from the international community's perspective and those who reflect upon the scenario in PNG, it's just not in the community's interests to proceed in that fashion. And there's a really good reason for PNG to demonstrate to international partners, but also to recognise that constitutional rights as a consequence of that delay have, it would appear, been violated. And if that's the case, then there are steps that can be taken to dismantle the system now that might be facilitated in the course of the 39th session upcoming. So I think that context hopefully is advantageous when we come to address these issues and assess PNG in this cycle.
Thanks, Matthew. And my understanding is that the Human Rights Council resolution, the topic of pardon and clemency and mercy, will be on the agenda for 2022 or 2023 as well. So it'll be good to see more attention to the global issue related to that. Innocent, I wanted to hear more from you about the issue of intellectual disability in Tanzania. What can you share with us about that topic?
Thank you again, Amy, for the opportunity. I'd just like to share the fact that even our courts do recognize that there is this matter, intellectual disability, that is also being classified by them as diminished responsibility. That is to say, it would also be better for the state to introduce new laws to make sure that, among other issues to be considered as mitigation factors, diminished responsibility should be there for there to be these commutations. And I'm really impressed with the statistics that I would again like to emphasize that in 2019, there were more than 480 persons who were sentenced to death penalty. So were in death row, I mean, including 19 who were sentenced to death penalty in that year and 9 who were later now sentenced to death penalty. That was in 2020. That is the reason why we should also at least have new laws that would at least lay or set down the procedures to be followed for commutations to be done. We have the issue of pardons, which we as Reprieve and other partners do because we do represent our clients. So in this case, we also try to prepare some pardon requests to be brought before the president. So we would like to have the laws that would prepare for would tell us generally the procedures to follow for that to take place. So that is the main thing that I wanted to share with you.
Thanks so much, Innocent.
Amy, can I just mention one thing in relation to St. Vincent the Grenadines? It's important for all our region as well. In the last UPR, St. Vincent the Grenadines had accepted a recommendation to bring conditions at all their detention facilities into line with the Nelson Mandela rules. But there's been no improvement in the prison facilities. They have one prison. Nevertheless, we know that understaffing, overcrowding, and sanitation issues remain prevalent. And it's the same in our own countries here, where in fact in Trinidad and Tobago, overcrowding and the facilities, the condition of facilities, we had a session a few years ago with somebody from abroad who came and was looking at our prison condition here, and he said it's not hell, but it's the room next to hell. So these are human beings. They're basic human rights that should be respected. So I just wanted to highlight that.
Thanks so much, Lila. Khomotso, any last words as we wrap up?
Nothing too major. I just think it's going to be very important to, keep an eye out for, any sort of increased signs of torture and non-compliance from the court systems, given the current status of the political and social landscape of Eswatini right now. I think things are gradually changing and citizens are growing a lot more aware about the things that they want and the things that they want changed. And that does sort of threaten the current system of governance. And so it will require a lot of awareness and pushing for a system that will adequately cater to that desire for change.
Great. Thanks so much. Well, we've reached the end of the hour and I want to thank everyone for attending. I also really want to thank our panelists for sharing their expertise and understanding of the situation on the ground. I hope you all join all of us in continuing to mark World Day Against the Death Penalty and the theme of women sentenced to death or executed. There are a lot of great events going on throughout the world by World Coalition members, so please check more of them out. And we hope to see you again later for our next UPR event. And we hope to see really great results coming out of the UPR session coming up in November. Thanks so much, everyone, for attending and for your contributions.
Thank you.
Yeah.
Thanks, everyone. Thanks.